filed a notice of tender payment. I'm challenging the jurisdiction.
Actually, that's not
That
correct. The file indicates that you submitted an affidavit of poverty.
on the order, it did not specify how to pay.
It was
Ma'am,
your obligation. Mr. Freehold,
respectfully,
please mute
ma'am,
Ms.
I need to
Ballard if
finish
she's going
what
to
I
continue to
have to
speak over me.
say. You cannot make a
Obviously, you
ruling over
disagree with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make a
did not hear
ruling
you.
over something you can't know. You saying you don't know is a
Before this hearing even begins, you need to understand exactly what you're about to witness, because this is not your average landlord-tenant dispute. This is one of those cases where reality and belief completely collide inside a courtroom. On one side, you've got a judge trying to follow procedure, maintain order, and apply the law as it's written. On the other side, you have a defendant who genuinely believes those laws don't apply to her at all. Now, this isn't just confusion, this is something much deeper. What you're about to see is a classic example of what's commonly referred to as the sovereign citizen mindset. That's where someone believes they can opt out of legal obligations, like rent, contracts, or court authority, just by using specific phrases, documents, or interpretations of the law. And here's where it gets intense. But the entire case hinges on one key issue: payment. The court requires actual verifiable payment to proceed with an appeal. But instead of traditional payment methods, the defendant claims she submitted something called a tender payment, a concept that sounds official, but as you'll soon see, raises serious red flags. What makes this situation so compelling is the confidence. There's zero hesitation, zero doubt, just absolute certainty that she's right. And that's exactly what turns this hearing into a slow, building clash between
I'm going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay, so what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make any presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, y'all.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60V, this is thrown out. I mean, it just, we don't have a contract. There's nothing to really argue here. So, I mean, it's clearly.
You can already feel the tension building, and it's coming from a fundamental misunderstanding of how court authority works. Notice what just happened. The judge is calmly trying to clarify the record, sticking strictly to documented filings, and while Miss Ballard immediately challenges the legitimacy of the ruling itself. This is a critical moment because it highlights a core conflict. Courts rely on documented evidence, filings, and procedure. But she's arguing from a place of personal interpretation rather than legal standard. When she says, "You cannot make a ruling over something you don't know," it sounds logical on the surface. But the judge does know because everything is based on what's officially filed. This is where sovereign-style arguments often break down. They shift the conversation away from verifiable facts and into abstract claims about authority. And the more that gap widens, the harder it becomes for the court to even...
Magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment, and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action. And the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk, it gets a little bit.
And it completely reframes everything. This isn't just a disagreement over paperwork. This is about unpaid rent and, more importantly, an outright refusal to recognize the obligation itself. That's a huge deal. Because once you remove the idea of a contract or deny the other party's ownership entirely, you're not just disputing details, you're rejecting the entire foundation of the case, and that's exactly what we're seeing here. The mention of fake documents and made-up legal terms is also key. Courts operate on established legal definitions. So when someone introduces terms that sound official but don't actually exist in law, it creates confusion, but not in the way they might hope. Instead of strengthening their case, It signals to the judge that the argument may not be grounded in
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Well,
So
actually,
I have to feel bad.
Actually, that's not correct. So the file indicates,
absolutely.
Ms. Ballard, the file indicates that you submitted an affidavit of poverty, and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I
Yeah.
tendered a payment in the magistrate court.
Right. And
Otherwise,
I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment, because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
according to law, I tendered the payment, and I don't know if there's some type of mix up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able, they even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while
Sure.
I get the information?
A real one. Instead of immediately shutting things down, the judge is opening the floor and asking, how do you want to present your case? That's a chance to clarify, simplify, and make a coherent legal argument. But here's the problem. If your entire position is built on rejecting the court's authority, then presenting that argument inside the court becomes a contradiction. You're essentially asking the system you don't recognize to validate your position, and that creates a loop. Because no matter how confidently it's presented, if the foundation isn't legally recognized, the outcome is almost predetermined. This moment could have shifted things if she chose to engage within the framework of the court, but based on what we've seen so far,
Can you tell me the case number on that? Is it this case number, 2023 CV 390111, or is it the 23 ED 284322 case number?
It's 23 ED 284322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a second.
Thank you.
Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay. That was filed. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. The Ms. Ballard has to comply with the order of the court before filing this appeal.
And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, you know, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made
Central claim. She's saying she's not a tenant and there's no contract. That's the entire defense. Now, in theory, challenging a contract is absolutely valid in court, but it has to be backed by evidence, documents, timelines, agreements, or lack thereof. You can't just declare that a contract doesn't exist if there's already a legal record suggesting otherwise. Also notice how she introduces terms like priority interest and challenges ownership itself. That's a massive escalation, because now she's not just disputing rent, she's disputing who owns the property. And that's a completely different level of legal argument that requires substantial proof. At this point, the judge is likely listening for something concrete, dates, documents, transactions, but
dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States, which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not illegal?
Things take a serious turn because now we're dealing with a factual claim that can be verified. She's saying she did make a payment. In court, that's not something you can leave vague. Payments leave trails, receipts, transaction records, bank statements. So when the judge starts asking for specifics like how much, when, and where, that's not pressure, it's standard procedure. And here's the issue. Instead of providing clear details, the answers stay general, all of it, continuous basis. Those aren't verifiable responses. This is the moment where credibility starts to come into question, because if the payment exists, it should be easy to prove. But if it can't be proven, then the entire argument.
In all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what
Yes,
law?
ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehouse, please mute
ma'am,
Ms.
I need
Ballard
to
if
finish
she's going
what
to
I
continue to
have to
speak over me.
say. I
Mr.
need to
Freehouse,
fin- how
please
can you
mute Ms.
make-
Ballard
how
if
can
she's
you
going to
make a
continue to
ruling?
speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not
Okay.
trying to be respectful. You're
Ms. Ballard,
interrupting me and not properly.
you are
giving me due
continuing to
process
speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe.
In, and this is critical. And the moment she says, basically, a money order, the judge immediately presses for clarification. Because in legal terms, basically isn't good enough. It either is a money order or it isn't. Precision matters in court. Every word, every document, every classification, it all has to be exact. And when someone starts hedging like this, it raises serious concerns. This is also where a lot of these cases fall apart. The belief is that if something resembles a valid payment method, it should count. But the legal system doesn't operate on resemblance. It operates on strict definitions and accepted forms. So now the judge is likely piecing it together. Whatever was submitted may not meet the...
That legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a
Obviously,
ruling over something that
brings it back to the one thing that ultimately matters: compliance with the court's order. Not interpretations, not beliefs, not alternative definitions, but actual, recognized legal tender. What we just watched unfold is a textbook example of what happens when someone tries to operate outside the established legal framework while still expecting protection from it. The judge gave multiple opportunities, asked for clarification, requested documentation, even paused to verify records. But at the end of the day, without proof of payment in a legally accepted form, the court has very limited options. The key takeaway here is simple but powerful. Courts don't run on interpretations, they run on evidence. And no matter how confident someone is in their position, if it can't be backed up with verifiable proof,
means it won't hold. Now I want to hear from you. Do you think arguments like this should ever be considered valid